We can go ahead and get started with the next speaker this morning. My name is Sean Marin. I'm a third-year law student and associate editor on the North Dakota Law Review. It's my pleasure to introduce our own Christine Fritz. Professor Fritz is a visiting assistant professor of law here at UND, teaching natural resource law, oil and gas, and elder law. For the past 10 years, she worked as a plaintiff's attorney representing royalty owners, and her talk today is going to discuss North Dakota class action lawsuits. So please welcome her.
Good morning, or the lack thereof. I should have followed that up with, or the lack thereof. Just a little bit of background. I'm from Oklahoma. You can probably tell I'm not from North Dakota. You'll get some accents this afternoon that are really southern. Then you'll say, mine's not so southern. But I practiced in Oklahoma for about 20 years. Graduated from the University of Oklahoma. Those of you who know Owen Anderson, I was able to come back and do an LLM a few years ago. And he is the director of the LLM program at OU. So I ended up having him, not the first round. I had Professor Hemingway the first round, and then I had Professor Anderson, and so I had him for 2 years in the LLM program. Through that, he introduced me up here, and they were looking for somebody to teach oil and gas as a visitor, and so that's what I've done for the last 2 years. So then we'll see where it goes from there. Could be more of a permanent position. So what I want to talk about today is a little bit about what class actions there have been and what there might be in North Dakota concerning royalty. And so that's kind of the overall topic. This is a little side note. We were out at Tioga this summer, and this is called an echo pad, if any of you have not seen it. 6 wells, same pad. They move the drilling platform. They walk it down. Each one of those wells is drilled down to 2 formations. They each go to the Bakken and they each go to the 3 forks. So they're producing, 6 wells producing from the equivalent of 12 wells, all right there on top of that one little echo pad. No above ground wiring. It's all underground. This is Amaretta Hess. You can tell with the green in it. You can't see the green very well, but green and yellow is Amaretta Hess. So they're building a gas, they're enlarging their gas processing plant. And so there's not, you don't see any flaring. There's no flaring going on here. And so that is going to be what you'll see more and more of in western North Dakota are these. They say they can go up to 18 or 32 wells all on one big pad. So it's pretty, because these are all horizontal, so when they go down, they're going in different directions. So they go, get so far down and go north, south, east, west, and then so far along down they can do it again. My understanding from working with the Petroleum Engineering School is that the Bakken is so tight that the circumference of when they frack and how wide that frack and how much that drains is so narrow that they actually can do it again, not that far away. So you don't have a drainage issue from somebody. It's harder to have a drainage claim or a drainage problem from somebody else's interest, and they actually can place those wells closer together to get more production. So we'll see the Industrial Commission has obviously dealt with how to handle this through their application. So from looking at it from the royalty owner side in the lease, there are 2 principal economic values to the lease. There are some minor ones, but the 2 primary ones are the bonus and the royalty. And the bonus is paid up front during stable times. Those may be $100 an acre, $50 an acre, $250 an acre. $500 an acre would be quite a bit for your bonus side. In North Dakota, in boom times, those bonuses escalate. My understanding right now, they're $2,500 to $3,000 an acre for that, and that is if a well is never drilled. That's money paid just for the pleasure of signing the lease. The second point is the royalty, and historically, those royalties have been an eighth And then they've kind of moved up to 3/16. In North Dakota, they're now leasing for 20%. And this is considered a non-cost bearing, and that's a big point of what we're going to talk about today. These are non-cost bearing interest. The royalty owner gave up to 80% of the production of the commodity in the ground in exchange for no risk and not paying any cost of production. So these bring up issues later on of how we interpret that. This is a typical, this is the Texas American Association of Petroleum Landman, typical for oil. We don't have much of a trouble with oil. Of course, right now we're producing tons of oil, so we really don't have too much of an issue with royalties being paid properly on oil because it's brought up, it's severed, it's put in a tank, and it's shipped off and sold, and it's a pretty simple process. So we don't have the same complexities that we have with natural gas. So there's some grade issues. You have to grade it, whether it be West Texas crude or Brent, or there's several grading levels. But once you know what grade you have, that's the grade you have pretty much in the whole formation, and then that's what it sells at. There's a price for that grade. So it's really there's not a lot of issues that go on with how we price it and how to calculate that royalty provision. But this is the problem in western North Dakota. Most of you have probably seen this. This is, you can see the lights. I don't know if I have the ability to do this today. But you can see the lights where it says, there's Bismarck, and those lights out in western North Dakota that look like some metropolitan area, that's the Bakken. And that is primarily, there's several sources of it, of why we have so much light. One of them is the increased lights from the rigs, because they operate 24/7. There's the increased lights from man camps, but primarily it is the flaring of the gas, because we're still flaring about 2/3 of the gas in western North Dakota. And that's because there's no facilities to process it. Gas is not neat. You don't just bring it up to the surface, throw it in the pipe, and run it down to a source and sell it. It is entrained with water. It's entrained with often hydrogen sulfide. So, and other products that can be brought out of it that we call it rich gas, casing head gas, that we can make better even use of than just the natural gas. So, natural gas comes up, it has all these different constituents to it, and they can't go in the pipeline. There has to be there's standards for pressure, dehydration, all these hydrogen sulfide, all these have to be taken out of the natural gas, and then it has to be compressed to a certain pressure before it is allowed to enter the pipeline. So these are all issues that happen once the gas hits the surface. And we're going to start seeing more and more gas produced. The environmentalists are screaming for it. The problem has been just the ability to do it. We don't have the plants out there. We don't have the pipelines in place to move it around. But that's happening, and there's some legislature that's been written that passed this last session that said that gas has to be produced. I think it's within a year of the time and you can't produce the oil without producing the gas. So it's not like we can shut in the gas portion and keep producing the oil. That's the other problem. Or we would just shut in the gas and wait until you get it hooked up. But this is gas. These are not gas wells. These are oil wells that are producing gas. And that's what happens. That's universal almost. So has significant gas. Price of gas, $2 an MCF. Not a lot of motivation for the oil companies to get out there in any hurry. A lot of motivation at $100 a barrel oil to get the oil to market, but not too much of a hurry for the gas. So this is a typical gas royalty clause, and what I want you to notice there is the language, if it's produced from said land and sold or used off the premises, the market value. So now we've got a term, market value. And then you move down a little bit further, and this is a 1/8, provided that gas sold at the well shall be 1/8 of the amount realized. So right there you've already created two standards for how much you're supposed to sell this gas for. And so therein lies part of the problem. So then you move over to what's going on in class actions. In Texas, primarily what they did is there's a couple. There's the tort reform issues that have come out, and what they did in Texas with tort reform is they reduced the amount of attorney fees to a point where these cases are not very attractive to attorneys. 4 times, you form a lodestar, you figure out what your base rate in hours, how much time they spent, and then you can multiply that up to 4 times in Texas. Well, I can tell you from experience that the last oil and gas, this type case that I was involved in, tried for 5.5 weeks before it settled. We had $1.6 million in advanced costs. We had been prosecuting it for about 8 years. We had not had a paycheck for about 8 years. So, and then there's a lot of risk, a lot of time, a lot of expense. So now you get your expenses, so set that aside, but as to your fees, if all you can get is a 4-time bonus for not being paid for 8 years, it's just not big enough payday. And attorneys are not going to take those cases. And you multiply that in Texas with what I'm going to talk about, the merit side of it, which is this first marketable product rule, and then you really don't have a lot of motivation, and I'll get to that in a little bit. So there's not a lot of motivation in Texas to file class action suits. Oklahoma, different situation. We don't have as strict a constriction on the attorney fee, so there's still, there's the big carrot out on the string, so we have that, and then we have a more lenient rule on this gas first marketable product rule. So in Oklahoma, you're still seeing hundreds of class actions filed for gas royalties. So in looking at that, the first problem that we have in looking at a class action suit is all these leases. That I showed you an example of one lease. Leases for gas have all these different terms. They'll have market value, market price, proceeds, gross proceeds, net proceeds, amount realized, and then they'll have different variations of combinations of them. So we have all these complicated terms in all these different leases. So when someone comes along and files a class action for a group of mineral owners, that the very first thing that will happen after a little bit of discovery is you'll have your class certification hearing. And it's always a matter, appeals, class actions always have, in any context, will always have an appeal after the certification hearing, regardless of how it goes, because so much is at stake, and it's an appeal of right. We want to get it right now, because if we go on to a class action, discovery is tremendously expanded if there is a class. Everything has to be handled as just multiplied many times. So we want to get it right here. So we have a class action certification hearing and determine whether we're going to have this class formed at all. And that's I consider that a fairly low standard to prove in mineral cases in most states, because this is the first thing that we have these criteria in North Dakota. Let's take North Dakota, which follows the federal rule for the most part, has a couple of little quirky portions of their statute, but I couldn't find where they'd ever been applied. For the most part, they do it just like every other state does in looking at whether to certify a class. You have all these factors that a judge can consider. Court has said they don't have to consider all 13, but these are the factors they have to consider. The one that we're going to focus on today is this: whether there's a common question of law or fact, whether that predominates the case. Well, what the defendants argue is that because of all these languages, all these different terms in the lease of how we're supposed to calculate the royalty, these all constitute separate contract interpretations. You can't throw them all together, so we just have all this different context. Well, they would have won that, but the problem that they encounter is They never calculated it differently. Every accounting system I've ever seen, they all just throw it all in, calculate it the same. They don't pay any attention to the language in the lease. So if the defendants aren't going to pay any attention to it, then the plaintiff's lawyers grab hold of that and say, well, that's jump up here for a second. So, the defendants focus on this commonality because of different terms, and that whole laundry list I said earlier. But there is a case in North Dakota. There's two cases in North Dakota that had to do with royalty owner class action. One of them was an old oil case, and it just had to do with the measurement of the oil. They were gauging the oil and mismeasuring it for like 15 years, and that was discovered by the tax commission, and so they brought a case. But there's only been one that dealt with these issues, and this was the Bice case that was originally, the first appeal was in 2004, and they followed the rule that the majority of courts follow, and found that, now this was a field-wide certification. They had about approximately 100 had previously sued Metro Hunt. So there were a lot of wells involved, a lot of mineral owners involved, but the court said that defendants are alleged to have calculated royalties for each plaintiff in the same way, regardless of lease language, and the propriety or legality of the deductions taken from royalty payments made to all these plaintiffs is in question. We conclude that Petro Hunt's standardized conduct toward the royalty owners presents a common nucleus of operative facts meeting the commonality requirement. So, if you're not going to look at your leases and separate them, then we're not either. It's common conduct, and we're going to go back and try to figure out what the baseline number was, and the baseline number is going to be the same regardless of how you treated it after the fact. So that's the way that North Dakota has gone, which is the way of most other states. There's a few minority cases which have actually thrown those cases out based on, we had a Fifth Circuit judge in Oakland, not Fifth Circuit, 10th Circuit District Court judge in Oklahoma, in the Western District, who did, and interestingly, he came from a defense firm who did a lot of this work, so it wasn't really much of a surprise that he then decided, because that's what he'd argued in his career, so he believed, and that's okay, he believed it. So that's the first hurdle. Once you get past the first hurdle of whether you have a class, then you're going to go on to the merits. And now this side of the case, once you get into the merits of a class action, it's really like any other merits, it's just on steroids. You're just deposing, maybe, it's an experts war, they're very expensive experts, it's an accounting war, depending on how many class reps you might have. I know at one time we had 19 class reps, didn't do that again, picked a few the next time. So a lot of discovery, a lot of paper, a lot of time, years and years and years. 10 years is not unusual for these cases to take a life of their own before they go to trial and then settle. Typically settle at some point, even if it's really late in the process. So there are two issues on the merits that I'm going to talk about today that are relevant to whether class actions could ever get any traction, in my opinion, in North Dakota. And one of them is, what is the market value or price of gas? How do you determine where and how and when do you determine that market value? And the second one is, because these are, these interests are non-risk bearing and non-cost bearing to production. And by what I mean, there's the question that has to then be asked is, when is the product produced? Because there are expenses after that. Moving the product, different costs and what are included in produced costs. Where do we draw the line where production has happened? And those are the two real questions that come up in this instance. So, and as not is unusual, when you take Texas versus Oklahoma, they have different opinions. So in Texas, this market value, the price that you're going to, move that, okay. The market price, is it the contract price? These cases arose out of long-term contracts. And so back when, years and years and years ago, companies entered into these long-term purchase contracts for gas, hedging that prices were going to go up. We'll buy it now with a small escalation factor, and over time, we'll get it cheaper. But the gas isn't produced till sometime in the future. And the question became, what should the market value of the gas be? Should it be the contract price? Or should it be the value that that gas could be sold for, but for the contract, if it were being sold on the spot market today, which could, and that's what happened. Gas prices started escalating. And so the mineral owners came in and said, in Texas, and said, we should get the market value. We should get what the gas is. Our royalty should be based on what the gas is selling for on, today, not what the contract says. And that was the question that was answered in Vila. And the court found in Texas, which I actually, just from personal experience, would have thought Oklahoma and Texas would have been opposite on this. But in Texas, they say that it's not the contract, but the price of the gas, the market value of the gas at the time the gas is actually produced. And that's the price you start with. So that's where Texas came out. And so, of course, the problem there is then you have to establish what that price is. What do you look at? Do you look at the fill? Do you look at all gas, similar gas, sweet gas? What gas do you look at? So there's a lot of factors, but they made a nice, neat, clean rule of distinguishing. We're not going to look at the contract in of itself. If it's a spot contract, then that would be evidence that it's current value. It's today's contract. But on these long-term contracts, they distinguished it that way. On the other hand, in Oklahoma, in Terra Petroleum, the Oklahoma court took the opposite position and said, if the gas is sold on a long-term contract and the contract was fair market value, arm's length transaction, then that is the price of the gas. And there's actually cases where it was used to lower royalty and to increase royalty, because there were cases where the prices went down, and if they'd been in Texas, they'd have lost money. So it works both ways, just depending on what the markets are doing, how volatile they are. So in Oklahoma, we're going to look at the contract. If it wasn't an affiliate transaction, if it were a fair market arm's length transaction, then the contract establishes the market value of the gas. So that's kind of our beginning point. There hasn't really been a case exactly on point in North Dakota. Not surprising, there's not a lot of cases exactly on point in North Dakota. That's what we're doing, which is what's kind of fun about being up here, helping develop and watch what's going on. So, but this is a tax case where they were trying to decide how to tax the product, and they were trying to decide on what value to tax the product. Do you tax it like the Oklahoma or Texas? And the tax statute was actually modeled after Oklahoma, so there was an argument in the case that, well, we modeled the tax provision after Oklahoma's tax provision, so therefore we should follow Oklahoma. But North Dakota did not. They followed Texas, and they say you look at the current fair market value, which, again, could go up or down. Gas is very volatile. So, it goes up in the winter, goes way down in the summer, and right now it never goes real high. So what it's valued at is going to be today's value, not a contract value that was entered into 5 years ago. We're not going to pay attention to that. So I would think if this issue were raised with the Supreme Court, they would use this ruling to extend it, which is what typically what happens. Because a lot of these cases come up as a tax case first. The state gets involved and sees something going on and goes out and tries to gather up some more tax information, and through that process, royalty owners find out and say, maybe I should look at my royalty. So that's I think that will be the North Dakota position for if there were a case on royalty owners. So then after that, then we look at at some point in this production process, this free ride stops. And we know it's production. We know it's at least till it comes up out of the wellhead. But what after that? That was the question. And that's been answered pretty well in all the gas producing states. Again, Texas and Oklahoma, two different positions. In Texas, along with California, Louisiana, Michigan, North Dakota, and Pennsylvania, have taken this property construction approach. So they look at production. Once the product is severed from the ground, it has been produced. End of story. And therefore, that's where you can start adding costs. You can start charging costs back to the royalty owner's interest in getting that product to market. And as I was talking about earlier, those costs can be fairly significant when you talk about dehydration, taking out impurities, all the things, taking out the water, the hydrogen sulfide. Those can be pretty expensive, and those costs aren't necessarily related to the price you're getting for the gas. I mean, it doesn't cost any less per MCF to remove hydrogen sulfide if you're getting $2 an MCF or if you're getting $15 an MCF. So it can be a pretty substantial proportion of a mineral interest, 3/16 or 20%, if you're producing hydrogen sulfide and that has to be removed. But in Texas, they took the position that compression, gathering, treating, hydration, processing, transportation costs are all deductible from the market value. So now we know what can be we know what can be deducted. We just have to figure out what that market value is, because as we said, in Texas, the market value is you have to come up with a market value. It's not the contract. At least in Oklahoma, you have a different problem, but you have a nice, neat, if you have a good contract, you've got a starting point. It's a little tougher to form your starting point. In states like Oklahoma, Kansas, Arkansas, Colorado, Wyoming, and they have differing approaches on this, differing views. You have, they look at it as a contract. What did the royalty, and my students heard some of this last week when Professor Anderson was up here, what did the royalty owner contract for? Did he contract for for gas mixed with water, entrained with water? Did he contract for gas entrained with hydrogen sulfide? No. His 1/8 royalty was based on gas. And so the approach in these states has been that what has come out as what we call the first marketable product rule. So the duty in Oklahoma for the producer is not only to get the product to the surface and sever it, it is to do the steps that are necessary that product can then be put into an interstate pipeline, can actually be moved into market. So you cannot, if it's hydrogen sulfide, you cannot charge the royalty owner a portion of the cost of taking out that hydrogen sulfide or compression or dehydration. That all has to be borne by the working interest owner, the producer. So once you do get a marketable product, you can then begin, if there are other costs, you can begin to deduct those so long as they are reasonable and increase the value in proportion to what the cost was. We don't know what any of that means. It just kind of complicates matter. But for our purposes today, that's it's a question of fact of when you actually have that marketable product. So we have an easier point because we know the contract is the market value, but we have a little more involved in trying to determine when we can start deducting costs. It's a little bit opposite problem of the Texas problem. In So there are three kind of variations of it. From Oklahoma to West Virginia has the most extreme. In Oklahoma, Kansas, and Arkansas, and then in Wyoming, Nevada, Michigan, they term production occurs when gas is captured and made marketable. Thus, above costs, or at least the non-moving costs, now transportation has been dealt with a little differently, are non-deductible until hydrocarbons are made marketable. That list of costs that I mentioned that are back here on this one. The compression, gathering, treating, hydration, processing are not deductible until you reach a point of having a deductible or a marketable product. That's the Oklahoma, Kansas, Arkansas. Colorado is one step further. All of that, plus it has to be gotten to the actual marketplace. In Oklahoma, you can charge transportation to get it to the market. And I think that was a concession that markets are often distant. So, but in Colorado, you cannot charge any costs, including moving costs. So you don't. And then in West Virginia, they even went one step further. Then you have to get to an ultimate marketing process, because you may take it to a hub. That might be a marketing spot, but it might be sold again to another point. So in Colorado, you could not charge to the hub, but you could charge from the hub further down. In West Virginia, you have to get to the ultimate point before deduction. So that's why West Virginia has the most royalty-friendly first marketable product rule. So those are kind of the three approaches to the first marketable product rule. So what did North Dakota do? Texas or Oklahoma? The second step, the same lawsuit, the buy suit, came back in 2009. Professor Anderson actually argued this case on the side of the royalty owners. And he just was here last week and told my students it was one of the greater regrets of his, career, but it was a great regret to him that he was not able to successfully convince the Supreme Court of his position. And they joined Texas. They joined the majority of states and said that marketable, we're not going to accept the marketable product rule. What we are going to do is say that when it's severed, then it has been produced by law, and regardless of what has to be done once it comes up out of the ground, all the costs associated that can be charged back. And that's exactly the way it works. It's a work back method. You take the price that they pay and you work back until you get all your proportionate deductions. So that was a summary judgment. So again, working in class actions, you're going to have this appeal on the certification hearing, then you're going to have an appeal and summary judgment to try to get through some of these kinds of issues, and typically those are going to go up as a matter of permission, and then again because it makes such a big issue on the case, and then thirdly, if you ever get to trial, you'd have an appeal on trial. But more often than not, by the time you've gotten there, you've kind of narrowed things down, and that's when settlement can happen, either into trial or during the appeal, because these companies really don't want these decisions out there at the Supreme Court. They'd rather settle them, and that's been the approach that's been made anyway for a long, long time. Too much money involved to take it all the way to an appeal on a trial, and trials are really expensive in these cases and last for weeks and weeks and weeks. So then, then you get into the question of what is included. Can you deduct depreciation, those kinds of things. You could make a claim for reasonableness of deductions and those type claims, but the fact that they can or cannot be deducted is determined by this point. So that pretty well limits. That's the other factor in Texas that has kept royalty owner class action suits at a minimum in Texas. And it'll be there's several factors that will keep class action work at a minimal in North Dakota. First of all, you very seldom see these cases brought during a boom, when there's big bonus money being paid. There's big, hundreds of thousands of dollars, if not millions, in bonus money being paid for thousands of acres of mineral interest. You've got thousands and thousands of dollars a month. You see these 6 wells, they're producing a lot of royalty for somebody. Everybody's happy. They're not looking for a fight. And so they're content, and there's nobody out there looking to file any class actions at this time. And you move on down the road, because of this ruling on this first marketable product rule, you're not going to see a lot of action. I don't think you'll see a lot of action. This is where the real money is these deductions. When you're down to just arguing whether something is reasonable or not, those are so subjective, and so what's reasonable and on what basis. Those are really hard to prove and really hard to win. So, and you've got so much time and expense in it that you're not going to take the risk on those type cases. So based on that, I don't see a lot of cases being filed in North Dakota on a class action basis. And in addition to that, you have more larger interest owners who don't need to be in a class action. They can go file their own lawsuit. In Oklahoma, we're so fractionated that there's just seldom would you have a case where one party had so much interest it would be worth their while to file it. But up here, that's not, it would not be uncommon to find interests who, they have a problem with their producer, their lessee, they go after them because there's enough there, and they're being funded pretty well at the same time. There are some other possible issues that could be brought, that have been brought, are brought in states like Oklahoma and New Mexico. There's a statute. In Oklahoma, we have a statute that talks about interest on late payments. And in Oklahoma, the rule's a lot different than here. North Dakota has a very, very generous producer rule. In Oklahoma, you do have 6 months to begin paying. So you have 6 months to get your production up and get your system in order. Once you get past that, then you have to pay within 120 days of production. If you don't pay within 120 days of production, then you pay 12% interest on any late payments. If there's a title issue, you only have to pay, if there's a cloud on the title, you don't know who to pay, you only have to pay 6% interest. Contrast that with North Dakota. North Dakota, you have 150 days to pay, period. So you almost have 6 months to pay from production. That's forever. And if you don't pay within the 150, it is higher. It's 18%. But if there's a title issue, if you have a cloud on the title, then there's no interest paid. So if there's a cloud on the title, they can put your money into suspense and never pay it, and never until it's resolved, and they never have to pay any interest. So it's a big difference, and that's a statute I think needs to change in North Dakota. I don't know if it's being abused or not. You'd have to look at it. Probably not. With 150 days to pay, that's pretty generous on its face. If you can hold on to the proceeds for almost 6 months, that's a long time to hold on. And once you start paying, you're paying month after month. Every month may be 150 days late, but now you're getting it every month. So as the landowner, you're not really too concerned the fact that you didn't get the first, you're 5 months behind. So I don't see that as being a huge issue. There's, and this is where that's covered right here, obligations to pay royalty. And then there are some exceptions. If it's a small amount, you only have to pay it once every 2 years. If they take their product in kind, that's not done very often, but if they do, then you're exempted from this. Title disputes that I talked about, and if you can't locate the mineral owner, then you don't pay any interest on that. So if you have missing mineral owners and you have them in suspense, you're just getting to use their money free of interest for however long it takes to find those. There could be some claims about what their duty is to find, but you got to find somebody first. Has an interest in that. In Oklahoma, we have found in this Leck versus Continental Oil case, Supreme Court has found that they recognize in a unit that's been prescribed by in this case would be appear to be the North Dakota Industrial Commission, but in Oklahoma it's the Oklahoma Corporation Commission, that if there's a unit and there's a unit operator who's assigned to manage this unit, that they have a fiduciary duty to all the mineral owners. And so that gives us a heightened level of scrutiny. And so anytime you bring a case, that's going to be one of them that you breached the fiduciary duty. And so that would then give rise to punitive damages if you have any kind of evidence of any kind of breach of their fiduciary duty. They knew they should have been not taking costs out, and they were, because they know the rule, and yet they started from square one. That might be a breach of a fiduciary duty on top of the contract breach. So it would kind of make it give you two claims. There could be affiliate transactions. Years ago, this is one way that companies used to try to do things. They think they kind of ran their gambit for the most part, where they would sell the product at the wellhead for a lower price, take it down the road, put it through the processing plant, drop out all the rich liquids, sell those, sell the gas for a higher price, but not sharing any of that with the royalty owners because it was the affiliate who had done all that. They hadn't done it. So you saw that a lot. But the Oklahoma Supreme Court has said no. If it's you cannot use an affiliate transaction. You cannot use an intra-sale, a company sale, to establish the market value of the even though we use the contract as the price, you have to go to your first arm's length transaction after that before you can start beginning to determine the prices. So when they're paying, in the middle of that clause, it says when a producer is paying royalty based on one price but is selling the gas for a higher, the royalty owners are entitled to have their payments calculated based on the higher price. The plaintiffs here are entitled to have their royalty payments based on the prevailing market price or the workback method, whichever results in the higher market value. So they're getting the royalty owners in these cases. If you're got dirty hands, then we're going to give the royalty owners the best they can find, whether it be the higher market price or the price that was sold later down the road. So we really don't have a North Dakota case on affiliate transactions. There was one that was brought, but the court did not reach it because they said in the evidence that had been presented didn't rise to a level. The affidavits on summary judgment didn't produce a question of fact. They weren't strong enough. There wasn't any evidence in them, and so they passed on it. So we do not have a rule on affiliate transactions in North Dakota, and this was working interest. This was not royalty owner interest. These were two working interest owners that were complaining about Coke and selling products to themselves in order to change the cost way it was passed on to the working interest owners. So in North Dakota, we don't know the answer to that. So those are some other issues that could be brought, but if you don't have a large claim like the market value, the cost, take out the cost, you can see what happened in Texas, class action suits between that and the reform that got rid of the possibility of high attorney fees, they all just kind of go away. And whereas in Oklahoma, they're just filed all the time. They're still being filed. And then we use we end up typically are able to use the discovery rule in Oklahoma because all the information, they report, we have a reporting statute, what has to be on the check stub, and it often will say deduction 0. Well, you're probably you should be able to rely on that if it says 0. But what they've done is they go past the point they made the deductions, and that's the price they use. And so they don't start with this price, take out the deductions, and then show your net price. They show your net price. And so they say no deductions are taken out. Well, no deductions are taken out over here. They were taken out over here. So when we get into discovery, we are able to go back behind the statute of limitations, and that's where these big lawsuits end up being, is because we get to go back 20, 30 years on these long-term contracts and have hundreds of millions of dollars of damages, which then settle for 60, 70, 80 million. So that's kind of the way the system works. And the discovery rule application is the other part of the puzzle, that if you can't get the discovery, if you can't get that rule in place, then your motivation for going is a lot less because it's such a smaller point in time. So that's where we're at in North Dakota. I don't think that you're going to see now or later, as we're going to start producing this gas, there's not going to, in the beginning, we're going to produce the gas, and the deductions are going to eat up the royalty. There's not going to be much royalty. But because they're also getting a lot of royalty from their oil, which will be reported separately, I see that as a reason why we won't see them. And then these rulings and BICE will definitely have an effect, the fact that we're going to follow Texas. So, any questions? I am not aware of that. I need to find out what's going on. I questioned whether that was going to happen, and my question on that, and I'd be interested to know the details, because I wondered whether royalty is being paid on that gas that's flared. Is that the claim? I would guess that they're probably arguing that that they're flaring the gas and they're not measuring it. Now, I've been told they are measuring it, but I would guess that because there's no market, what are they paying? I can see that if they're not filing, if they're flaring the gas, the argument I think the royalty owners are going to make are one of twofold. One is either they're not paying any royalty on it, they're just flaring it. That's a possibility. And if they are they paying royalty on what they would have been able to pay had they actually marketed the gas? Or are they paying it on some reduced amount, minimal amount, whereas maybe they could be capturing it and selling it, putting it through the processing plant, drop out the rich parts. So would there be more money if they were actually processing it? Because to a large extent, the gas is a nuisance to the production of the oil. The oil is what they want. Gas is just, and so there wasn't any real motivation to get, because if there's not a lot of motivation on the side of the big oil companies if they're only producing the gas because they can't do it they can't not produce it, and so they'll end up with that. So that's going to be the two issues, and one's pretty easily answered if they're measuring where they're measuring it. That's easy. Find out, end of story. They either are or not paying. But secondly is what price. That would be the other factor that would cause you to be able to say, if you could show that they're not paying it on a higher price, that they could have processed it and produced, then the royalty owner's not getting their share of royalties, and they have violated their covenant to market, is what that would be. Yeah, it would be. Yeah. I'll have to check that out. I'll have to talk to the lawyers who filed it and see. Follow that? Okay. I'll have to get a hold of them. Go talk to them. That'd be fun. Have them come talk to my students. So I tend to be, as you can see, a little bit towards the royalty side, mineral side. Somebody's got to be. So, any other questions? No, they're not an outlier. Oklahoma, the Koch brothers are pushing hard. It's just part of they kind of sneak it in. The oil and gas side of it is snuck in through the medical malpractice and the fees and how high the fees are. And nobody really understands what that's going to cost to happen on the oil. There's no mention of oil and gas in there. But when we read them, we know the effect of it. But no, Oklahoma's been trying for a while. There's been some reform. They haven't gotten it completely, but Texas is really the lead in it. But no, I see any strong Republican states are going to be looking for that. And any state where there's large production of minerals, then your Republicans and as a group and your oil companies are going to be funding those efforts to get that change, because they know that's the motivation. If you don't have why go to all that work and effort if all you can do is make essentially your hourly fee that you could have otherwise made and gone home and not worked 80, 90, 100 hours a week for 10 years? In Texas, yeah. Class actions are almost non-existent down there. There might be, something like this would be one that could, there was a bunch of flaring, they may claim a claim, but it wouldn't be the big guns, typically. And not going to be some exception to that, but typically. There's still a piece in this lawsuit that I was involved before I came up here that still has some Texas claims in it. But it's going to be reasonableness of deductions, and that claim would not have been filed by itself. It's being litigated with an Oklahoma and Nebraska. It's one big, huge, nasty conglomerate of stuff that'll probably outlive everybody in this room. So, anything else? Well, thank you for your attention.